everyone, and welcome to the ALCTS webinar, Can I Copyright My Data? I'm Eva Sorrell, a member of the ALCTS Continuing Education Committee, and I'll be your host for today's webinar. Our presenters today are Sandra Enimil, head of the Copyright Resource Center at the Ohio State University Libraries, and Amanda Rinehart, Data Management Services Librarian at the Ohio State University Libraries. Sandra provides information and resources on using copyrighted materials and assists creators in protecting their own copyright. Prior to working at Ohio State, she was the Archives Copyright Manager of the Chicago Defender newspaper. Sandra has a law degree in addition to her MLIS. Amanda comes to university libraries from Illinois State University, where she served as data librarian and head of the Digital and Data Services Department. Prior to that appointment, Amanda was eScience librarian at Brown University and worked 11 years at the U.S. Horticultural Research Laboratory of the USDA. Their presentation will outline the current landscape of data sharing and intellectual property ownership and discuss how copyright applies to data. A few things to keep in mind for today's presentation. Today's webinar does not have interactive chat capabilities. If you wish to comment on today's presentation using Twitter, you may use the hashtag you see on the screen. We will not be monitoring the Twitter feed. If you have questions for Sandra and Amanda, please type them into the question box on your screen and they will answer them as time permits at the end of their presentation. Questions which remain unanswered while we are on the air will be answered offline and the answers sent to all attendees. This webinar is being recorded and you will receive an email with links to the recording, the presentation slides, and an evaluation within 2 days. Please take time to fill out the evaluation form since it will be used by the committee to plan future events. There may be a slight delay as I turn the presentation over to Sandra.
Hello, my name is Sandra Enimil, and I'm here to talk to you about copyright and whether or not you can copyright your data. I just wanted to show you briefly what we're going to talk about, what Amanda and I are going to talk about today. And hopefully we'll answer any questions that you might have about what copyright is. That's going to be my job, and then whether or not data can be copyrighted. And Amanda's really going to talk more about data management issues. And hopefully we'll be able to get into a really good discussion and help you all with any issues that you might be encountering. So the first question is, can data be copyrighted? The short answer is no, but I'm sure most of you are here for the longer answer, which is that there may be other rights and other issues involved, and even though you can't rely on copyright to protect data per se, there may be other ways that you can protect data if that's something that you're interested in doing. Before I really get started into what is copyright and what kinds of things are copyrightable, I wanted to talk about other intellectual property rights that are available that may have implications for data or may be impacted by data. So the other areas of intellectual property rights, which some of you may be working with or working through or managing the process with, could involve patents, which are for useful discoveries and innovations and improvements. Trademarks really talks about logos and identifiers for businesses. Trade secrets has to do with business formula, so the KFC secret recipe or the secret sauce and for any restaurant are things that they can protect under trade secrets. And copyright, which is what I'm going to spend the bulk of my presentation talking about, has to do with the expression of creative works. And that expression has to be in a tangible medium. So I'm going to, as I said, specifically talk about copyright law. And for some of you, this may be some basic information that you're already aware of. But I wanted to give some background on copyright law and to talk a bit about authors' rights because those things are implicated here as people are creating research, scholarly works, and just having an understanding of copyright law I think will help in as you're managing your copyright and also in thinking about data as a whole. So a lot of times in the work that I do, people will say to me, you know, copyright, I feel like I'm hearing about it all the time. It seems like a new thing. And I would like to point out that it is not a new thing. It's, you know, something that was discussed at the Constitutional Convention. It's a part of U.S. U.S. copyright was conceived of and thought about during the U.S. Constitutional Conventional process. So it's a part of our Constitution where there's protections for creators, for people who are creating patentable items, for people who are creating songs, people who are creating books, etc. The idea was to have a balance between people who are creating things and the users who may want to use those things that are being created. There was a grant to authors, inventors of exclusive rights, which I'm going to talk about a little bit later, for a limited time where they would have the opportunity to exploit and make money and do all kinds of things with the work or material that they've created. So that during that time, which now for U.S. copyright is the lifetime of the author plus 70 years, they are able, or their states are able, to make any benefits that they can. Once that time period ends, and I know that it's a very long time, again, life of the author plus 70 years now is the term of copyright, the author is able to have many benefits and they're able to exploit their works however they want. When that time ends, then the public is able to use that work without getting permission from the rights holder. This work becomes a part of the public domain, which is another concept I'm going to talk about a little bit later. So that you guys can understand what can be protected. Original works of authorship that are fixed in a tangible medium of expression. I have a picture here that shows a whole bunch of different types of things that have received copyright protection. You'll see photographs, books, movies. All of these things can get copyright protection because they are expression that has been fixed into a tangible form. So here is a list of the things that were included in the 1976 copyright law, and as you can see, many of the things that were on the previous picture are also included there. One of the ways to think about how things can be protected is to think about fixation. So the fixation part is very important in terms of if I'm talking to you, if this webinar were not being recorded, just me speaking extemporaneously cannot be protected. The fact that it's being recorded is what gives the protection. So it has to be fixed into a form that can give protection. So the things that cannot be protected, I've already mentioned that data is one of the things that cannot get protection. The other things that cannot get protection are things that are in the public domain, works that are not fixed into a tangible medium, like I just said, ideas, facts, works of the U.S. government that are produced by government employees. So these things cannot receive any type of copyright protection. I wanted to talk to you also about authors' rights. So as a creator, some of you have probably many copyrights in journal articles, books, etc. These are the rights that you have when you create something. You have the right to reproduce the work, so you can make copies of it. You have the right to prepare derivative works, so you write a poem and you want to turn that into a song. You can do that as the creator. You have the right to distribute it, so the copies that you made earlier you can give to other people. To display whatever you created publicly and to perform it publicly. So if you wrote a song, you can perform that song because you are the creator. And these rights are yours until you give those rights away. One thing that I wanted to stress is that copyright currently under U.S. law is automatic. So anything that you create is protected instantly by copyright. So you do not have to do anything. You don't have to register if you don't want to. Registration does give some legal protections if you wanted to bring litigation. You will have protection. You will have greater protections through registration, but you do not have to register your copyright under our current system. And again, works are already covered by copyright, and it is yours unless the work you created was a work for hire. I'm going to talk a little bit more about work for hire in a moment. One thing when I'm talking to some academic audiences or research specific audiences is I want to talk about student works. Student works are also covered by copyright, and unless they are an employee and that employee situation has been clearly noted, those works are still covered by copyright. So sometimes I'll get questions from faculty about using the student work, and they'll be surprised when I say, well, you do need to get the permission of the student because the student created this material themselves, and copyright does apply, even though as a faculty person you gave the assignment. But they are still protected by copyright. And also anything that's done in digital form, things that appear on the internet, blogs, emails that you create for work, those things can be covered by copyright if they are considered put into a tangible form. One thing that's important to know and to think about in terms of the work for hire status is, what is your university policy? At The Ohio State University, there's a distinction between staff employees and faculty employees. As a staff member, I can speak for myself, I'm a member of the staff here at the university, and anything that I create as a part of my work duties is owned by the university. So anything that I create is a work for hire. That just simply means that I'm creating something that is necessary for my job, and so when I finish creating it, The Ohio State University is the entity that will have copyright in that. I've created that work, but the copyright does not belong to me. You also want to look at your university policy in terms of what it says about traditional scholarly work. Most universities, including OSU, do not claim copyright in traditional scholarly work. And this might be something that's restricted to faculty who are doing traditional scholarly work. And that can be in the form of books, journal articles, also blogs, anything that could be considered traditional scholarly work. Most universities are not claiming copyright in that. So you will own that until you decide to give it away, or you decide to license it, transfer it, give it to another institution, or what have you. Whatever you decide to do with it, it's your copyright until you decide to do something else with it. But you want to be sure that you understand what policies are in place, whether you're at a university, archives, museum, wherever you might be. You want to make sure that you understand what the policy that's in place for things that you create. For things in which you maintain your copyright and you keep the copyright, you want to think about ways in which you may want to think about giving it away or not. I've listed here a few different options for how you might want to make work available. So an example for me is if I created this webinar for use, that's something that I would be doing here at Ohio State, I could put a copyright notice on there that says 2014, The Ohio State University, to make note, to let people know that the copyright belongs to The Ohio State. If you are creating something, you can put copyright, the year, and then your name, so that people know that you are stating that you have created this. But I do want to point out that the copyright notice is not necessary for there to be copyright protection. So we don't necessarily have to do that, but it's helpful for people if someone comes across any material that we've created, that they know that it's been created by someone at Ohio State. Ohio State has the copyright. They can link back and try to, if they are interested in using that material, they can figure out who to go to. As a rights holder, you can also say all rights reserved. You can put that language on whatever you're doing so that people know that you're not making it available for any kind of use. You are reserved all of the rights that were listed earlier for yourself. So no one can, make any claims about rights. You can also look into Creative Commons. Creative Commons is an organization that was created by lawyers, librarians, and lots of people in the community to give away to make way for people who are creating material to provide that material to others to use. There are several different licenses that are available, some with just the basic attribution. So if you find some material on Creative Commons that you want to use, if it's just attribution, the only thing you have to do is say where you got it from. Some of the other licenses ask that you share the license in the same way. Others ask that you don't make derivatives or you don't use it for a commercial purpose. You can find material that way, and also if you want to contribute material to the Creative Commons, you can use their licensing structure. You can also use other types of licenses or terms of use if you put some kind of material out. You can list in the bottom, in the footer, or the header saying how you want it to be used. Typically, we'll see things like educational, non-commercial use, and so you're letting people know that they can use the material as long as they're using it for the terms or the purposes that you lay out. You want to make sure, if you're retaining rights, that before you post on social networking sites or some of these social research sharing sites, that you have the rights that are necessary to be able to post that material. You also want to have an understanding of any funder mandates that you may have. Additionally, and lastly, you want to make sure that if you decide that you want to publish your material with a journal or some type of publisher, that you understand what rights you may be giving away completely, or what rights you may be retaining, or what rights they may grant back to you to be able to use your material. It's important to note here that if you transfer your copyright, the copyright no longer belongs to you. You have to make sure that you understand in the contract that you sign or agree to what kinds of rights you have, or whether your rights are completely gone, and that means that you cannot, even as the creator, even as the author of the material, you're no longer the rights holder, and you cannot do certain things with that material that you could as the author or the rights holder initially. So just make sure that you understand what those things mean. So now I've finished talking about copyright. I look forward to hearing your questions. At this time, I'm going to turn it over to Amanda. Please bear with me as I turn it over to Amanda. It may take a few moments. Thank you.
Hi, my name is Amanda, and I'm the Data Management Services Librarian here at OSU, and I'm going to talk about what it's like when you are talking with a faculty member and they bring you this question, when they say, can I copyright my data? I really tend to flip the question on them or dig a little deeper. As we know in reference interviews, sometimes what they're asking isn't really what they mean. And so I try and get to what are they trying to accomplish with copyright? What kind of protections are they trying to do? Often it comes out that they're trying to get credit for their data, particularly true for faculty who haven't shared in the past and whose community is changing over to that. So just to make sure that we're all on the same page, Sandra talked a little bit about copyright in general. I'm going to talk a little bit about research data in general. You know, data used to be just numbers, right? And now we've kind of expanded that definition to include any unit of information that is observed, collected, curated, or created in the course of research. So this kind of expands this conversation quite a bit, because now we have all kinds of different things being considered data, being used for research, and maybe they don't quite fall into the category of numbers anymore. So I just wanted to give an example of what I'm talking about here. So we're all familiar with books. A book is a copyrightable creative work, but now we have these large collections of digitized books like HathiTrust, and they are mined for research purposes. So that entire collection of books, of that collection of text altogether, can be considered data. And so we're crossing over with our definitions here, and it makes it a little bit confusing. It's something that it takes people a little bit of time to get used to, because this tends to make copyright a little difficult when you start thinking about this. What I encourage is you know, some formats are commonly copyrighted. Sandra listed a number of them: literary works, music, drama, pictures, graphics. Well, now we're saying that any or all of these formats can be data as well, depending on the context in which they're used in. And so I call it the format trap. If you start thinking of this type of file is copyrightable, you can get a little bit hung up when talking about data. And I'll show you why. So when you get into working with data, you start talking to the researcher, there's often different versions of the data, and these are captured in different formats. So what we have here is an image of bacteria, and photographs, images, typically copyrightable, right? And then the researcher takes that bacteria, puts it in this 96-well Petri plate. It's another image. I don't know if you could argue the creativity factor of it. That would be a debate. Maybe it's copyrightable, maybe it's not. And then, of course, the 96-well plate actually outputs a bunch of numbers in a table. Well, numbers, clearly data. And in general, many people would say that's not copyrightable. So if you start going file by file to try and put whether it's copyrightable or not, you kind of get into these long, winding conversations about how much creativity went into the work and is it really tangible, that sort of thing. What I encourage is say, well, what type of material is included in the data set? So you don't think file by file. It's quite possible that all of these two images and the table together, are what makes this data reusable. The next researcher might need all three of these. So first focus on sort of that bundle of data that's reusable. It's a data set, and don't get too caught up in the formats that bundle of data exists in. So just to reiterate there, I know for some people this will be a little bit new thinking about it this way. Research data, it depends on the context. You have to be using it in the course of research. It could be a collection of almost any type of format. And reusable data sets may not all be of one format. Quite frequently, they're not. So I typically start speaking with individuals who come to me, can I copyright my data? I say, okay, so what data are we talking about? And we kind of get into, all right, so you have all these files. What's reusable? What's the group of them that's reusable? It might just be one file. It might be a whole set of them. And then I say, so what do you want to do with this? Why do you want to copyright it? Because technically copyright, as Sandra mentioned, is automatic. So as soon as they wrote it down in a tangible form, as long as it's creative work, there should be a copyright to it. Chances are, I'd say 9 times out of 10, the person is more concerned with other issues, and they're trying to use copyright as the vehicle to get credit or protect their data. So when it comes out, well, I want to get credit for it, or I want to track it, I want to make sure that people know who this is coming from, that's when I start talking about data citations. And data citations are very similar to regular citations for text, and that they include the metadata, author, publication date, title, all those sorts of things. Specifically, DOIs are very handy in these citations. They really allow backtracking. And there's quite a bit out there about how to cite a data set. I see more and more people doing it now. And you have to emphasize that this is really the scholarly way to get credit for sharing a data set or creating a data set. It is not necessarily a legal vehicle. It's simply a way of getting credit. And the Australia National Data Service actually has this wonderful graphic that describes sort of how this works in the scholarly world. So we see here at the top, we've got DOIs used in data citation, and then of course the research community reuses the data set, cites the DOI. There's impact metrics, just like we have right now with literature. That impact results in, tenure and publication and happiness, and then of course you go on to create more data sets. So one of the challenges we have is publishing the data set, and typically repositories do it a little differently. The DOI is the standard. Certainly the Australian National Data Service assigns DOIs. As well, there's an organization that's come together to help assign DOIs to data. It's called DataCite. They will provide DOIs to data sets, as well as they talk a lot about workflows and standards for sharing data. DataCite is out of the UK, so it's a organization that does charge a subscription fee. And because of that, I don't think there's a whole lot of organizations in North America that belong to that yet. So I did put up a map here. We can see that Purdue belongs, Harvard, and the California Digital Library belongs. It's certainly something that I think as we move into this field, we're going to see a lot more data citations, a lot more inquiries about them, and a lot more need to assign DOIs. This is an option. I think you probably have to get to the point where you're publishing a lot of data sets to make this worth your while, but it's certainly lovely that it's out there and waiting for us when we get there. So that's sort of the easy way of saying, oh, we'll just put a citation on it and then you'll get credit. But the reality is, in real life, some researchers aren't used to this yet. And I just wanted to put this up here because it's a really relevant example, just happened in October, of some researchers. They shared their data. They put all kinds of statements on it, including this one that said, data users who make use of this licensed data must cite the relevant primary original publications. Okay, great, you're citing where the data came from. And then they went on to say, authors utilizing this data are required to list the following individuals as co-authors on any publications. So this is a group of researchers who are new to this environment. They were probably being very cautious. They want to make sure that they get credit, that maybe they're not so comfortable sharing their data yet. And it was highly unusual that they would say that we require anyone who reuses the data to put us as co-authors. And because this particular community is a little new with this, there was a backlash to it. A lot of other researchers saw this. They became a lot of discussion about, well, is that right? Does that justify co-authorship, just sharing the data? A lot of that discussion went back and forth. These particular researchers actually came out and said, we'd actually never require that. It was sort of in the language. So be aware out there that depending on the communities you're working with, they might be really confused about exactly how this new world is going to work for them. I certainly encourage everyone to do a data citation, a suggested citation on their data sets, and then requiring reuse as co-authors, that is highly unusual, and I think they would have to justify that to their peers. So I just wanted to put that out there, that it's very easy to say that we should do these things. It can get a little bit more confusing in practice. So we kind of covered getting credit. And a lot of people are trying to use copyright to get credit because they're very familiar with the copyright conversation regarding their articles, and they might think of their data the same way. But they also might be concerned about protecting their data and specifically restricting it. So this is usually in a situation where they're not sharing their data publicly, or they don't want to share it entirely publicly. It might be a little bit out there. And this goes back to what Sandra was saying a little bit about OSU policy, intellectual property policy, and the traditional academic works. So a journal article or a book chapter is considered a traditional academic work, and as such, the researcher has the right to assign copyright over. However, data sets, according to OSU's policy, are not considered traditional academic works. They are considered the intellectual property of the university, and this is pretty typical in the U.S. So OSU does have a research data policy. If your institution does not have one, I would strongly encourage you to check out this publication by Ricky Irway. It's called Starting the Conversation, University-Wide Research Data Management Policy. It's really good overview of just how to start this, kick this off, start getting the right stakeholders on campus to consider what kind of research data policy you want to put out there. In OSU's data policy, it does say that the university owns the data, but the PI has the right and responsibility to ensure that it is reported to the scientific and academic community, as well as to select the vehicle for publication or presentation. So it does give the PI some rights. However, they do not own the data. And that is something that can be a little bit controversial to talk to them about. But as long as they understand that there are vehicles for doing what they want with the data without necessarily having ownership. So what we tend to get into when you start talking about sharing data is data governance. And I'm just going to touch on this very, very lightly because it starts getting complicated really, really fast. And we're moving farther away from copyright and kind of into all these other laws, depending on what type of data it is. So if it's educational data, it might fall under FERPA, which hopefully many people are familiar with. HIPAA, I'm sure we've all signed HIPAA forms at the doctor's office. There's also export control laws. There's obligations that they may have stated to the institutional review board if they're working with human subjects. They might also have personally identifiable information that, again, would harm human subjects if you put them out there. And also, we can't forget the patents and the trade secrets and the trademarks and all these other sorts of things. So because the university owns the data, they're the ones who are responsible for making sure that all of these laws are met or followed. They're liable if these are violated. So it's very important that the researcher understands that it's not just sort of checking off a list when they share the data. They might need to accommodate any or all of these laws depending on what type of data they have. I'll be honest, as a librarian, I do not take it on myself to know all of these. I just make sure that I know who I can consult with on them. So if you are somebody working on a university campus, I highly recommend getting to know your export control officer, getting to know maybe technology transfer lawyers, certainly your legal affairs. They're wonderful, by the way. You go to them and say, hey, we need to do this with the data. How can we do that? They're great about helping you navigate this. It can be a little new for some people, so it's important to consult with the right people. So when you boil it down, after we look at all those laws and things, university policy, all that sort of thing, you can put a reuse statement on the data, something that restricts it. And it could be a copyright statement, sometimes it is, but it could be a license, it could be a data transfer agreement, or a data use agreement. A data transfer agreement is commonly used when a researcher leaves the institution but wants to take the data with them. And it's simply another legal vehicle that says you can take this sort of data under these circumstances to do this with it over here to this other institution. A data use agreement is saying that the people that are reusing it can use it for specific purposes or under a specific condition. It does get terribly complex, so definitely I always recommend asking for help with this. So let's see, I covered the data transfer agreement and the data use agreement. I did want to point out that you may have seen some of these. If you work in the data world, particularly if you've ever pulled up data in ICPSR and it says no public access and you have to fill out a form to get access to it, that is a data use agreement. So these are actually quite common. I just don't think they're commonly spoken about or sort of acknowledged when we talk about how we're going to protect the data. So I did want to provide a concrete example because sometimes this can sound a little vague and a little out there and a little scary. Recently, we had a sort of a flag come through in our acquisitions department. Someone was mining the metadata from a vendor database. They had done it with an automatic computer script. This looked like that someone was violating our license. So of course our acquisitions department, our e-resources librarian, got a flag. She was kind enough to track down the researcher and say, hey, why are you doing this? The researcher said, oh, well, I have this great research idea. I need this metadata so I can create this subset of data and I could do this, really interesting thing with it. And actually, the acquisitions department contacted the vendor and said, under these conditions, would you be willing to let this researcher do this? And the vendor was, but they wanted to know if they could receive the derivative data set and receive it exclusively. So at that point in time, we needed a legal method by which we could kind of arbitrate this, and that turned out to be a data transfer agreement. But at that point in time, we reached out to Legal Affairs. They were great. They helped set us up so that we could do that. We did not try and include this type of use under our current license. We felt that that would be a little bit tricky. So we set up this other agreement, and it did facilitate this. So that's sort of an example of what can happen, particularly as we see more and more people looking to mine metadata that we license from vendors. Either the license doesn't accommodate it or simply doesn't allow it. So just to recap, I will get an email from a faculty member or somebody who wants to share their data. They say, hey, how do I copyright my data? And I say, well, what kind of data are you talking about? Are you concerned about getting credit for it? Is there a specific reason you need to protect it or restrict it in some way? And after I get the answers to that, I'll always recommend to attach a citation because definitely we want to get, appropriate tracking and credit. And then if we need to restrict it, if we need to do some other things, then some form of a reuse statement that might refer to a data transfer agreement or a data use agreement, to another license that's worked out. It kind of depends on the individual situation. So I just wanted to recap, and I'm going to repeat some of the things that Sandra mentioned. Common facts and ideas are not copyrightable, and that may be data in your data set, might not be. The creative expression of facts or ideas is copyrightable, so that tends to be that gray area where you're talking about, well, is this a creative expression of this fact or not? Definitely a lot of what you do is going to be governed by your university's policies, both the intellectual property policy and any research data policy. If you don't have a research data policy, you might have to default to the institutional data policy, depending on how your university is classifying them. Please be aware that the word data has changed. I begin almost every conversation I have with a common definition of what are we talking about as data. It really helps clear away the cobwebs and get you down to brass tacks. Always recommend a citation. And even if copyright doesn't apply, say to that table of numbers, you can probably still attach a reuse statement, depending on what you want to do with it. And that will, again, circle back to if the university owns the intellectual property of the data, but the researcher has the responsibility for managing, sharing, and publishing it, typically the researcher gets to specify what they want to do. And at the end of the day, that's generally what we're trying to get to. The researcher doesn't feel they can share or wants to share under certain circumstances. I always tell them there's a way to get to what you want to do. It's just a matter of working with the people we need to work with to get there. So I hope that our conversation here so far, the information has given you some good things to think about, to work with, maybe established a common language for us. And what we'd like to do now is take any questions that you have. I believe that Emily is going to arbitrate our questions for us.
Actually, I am Eva.
Sorry, Eva.
That's okay. So if you have questions for Sandra or Amanda, please type them into the question box. Okay, the first question is, can you address the question of who holds copyright in the case of interview data? Would the copyright on an interview answer belong to the interviewee, the interviewer, or is this a case of jointly held copyright?
Okay, this is Sandra. I'm going to try to tackle that one. With interviewing someone, you do want to start off with getting, if you feel necessary, and I think it's probably a really good idea to get their written permission to record their answers. And I'm assuming that you mean in the written formation of the answers. So once it's you're doing the interview and someone has done a transcript or done some kind of writing of what the answers are, asking whether or not there's copyright in whatever that fixed document is. And if that is the question, typically with copyright, it's the person who actually does the thing. So another example would be if someone is recording an event. The person who is holding the camera is the person that would have copyright. In this instance where you're doing an interview, you want to make sure that you have permission of the person that you're interviewing. I would recommend that you get that in writing, that you have permission to record them, you have permission to transcribe whatever it is that they're saying to you. In that instance, you can say that there is a possibility of shared copyright, but really those are the kinds of things that you would want to spell out, that you are sharing copyright, but in most instances, copyright belongs to the person who is actually putting it into the fixed form. If people are contributing to it, there is a possibility of shared copyright, but usually, as I was saying, that it's usually the person who is putting it, who is fixating, who is making it into a fixed form that would hold the copyright in that.
Okay, thank you. What are the pros and cons of using a data use agreement versus a CC license for data sets? Is there a trend towards using one or the other more prevalently?
I can tell you what my experience is. This is Amanda again. So there is a CC version that is out there for data. I have not seen that commonly used. The reason for that, I believe anyway, is that copyright can be debatable with data. So it may apply or it may not apply. So the Creative Commons license is sort of assuming that there is a copyright, that it's copyrightable. So I haven't seen that used as much as I've seen data use agreements. Data use agreements are very specific and tailored, so if you want it to hold up to kind of scrutiny, the data use agreement is probably going to work quite a bit better than the CC license. Now that being said, if you're sharing publicly and you just want a reuse statement on it that says this is my preference for it, or you don't feel that it would be challenged or misused or that sort of thing, then probably a CC license would be okay. It really is a judgment call, and it really can be up to the university or the researcher.
Okay, thank you. If you're at a university where the faculty own their research data, meaning it doesn't transfer to the university, and faculty want to license the data or sell it to others interested in working with that data set, is that effectively requiring a reuse agreement?
That's a new one to me. The Bayh-Dole Act of 1980 let American universities make money essentially off of their research, and that directly related to universities starting to patent research. And patents are, you know, behind them is the data. The data is what you have to own the data in order to patent it, kind of thing. So. But if you're saying the university has no interest in it and has no right to it, then I would assume that the faculty could simply sell it. Sandra, what do you think about this?
Yeah, I mean, I think if that is the case and the university policy like clearly says that they're not making a claim in research data, and that the faculty or the researchers who are involved with creating the data are the ones who have ownership of it, if that is the case, then it would be their right to do whatever they wanted to do with it. Yeah, I agree with what you were saying, Amanda.
Okay.
Okay, thanks. If data are not copyrightable, doesn't that make the data in the public domain, which means the university can't place reuse restrictions on it?
So we're saying that data, I mean, as a part of U.S. copyright law, data is not included in that. But that doesn't mean that there aren't other rights that are involved. Amanda just mentioned patents. There are also trade secrets. What universities are claiming is not a copyright in data. They're not claiming that. So that doesn't mean it becomes freely available to anyone. But it means that the university is claiming whatever particular right they want to claim in that material and saying that the researcher, the faculty member, may be able to do some things with it, they may be able to share it, but the rights belong to the university. So they're not claiming a copyright in the data. but that doesn't, you know, so that doesn't mean that it's freely available to be shared. Amanda, I don't know if you had anything else you want to add to that.
I would just remind people that the one slide that listed FERPA, HIPAA, and all those, that sort of laundry list of regulations, data governance is ruled by a lot of federal law, and we don't see those same complications or that same law. Copyright is one law of the federal government, but so is FERPA, and so is HIPAA, and so is a number of other ones that say you need to protect human subjects and things like that. So there can be quite a few other restrictions or regulations that you have to meet that's just completely separate from copyright.
Okay. If I'm a faculty member at a university and I collect interview data on my own time, does my university have rights to this data?
That is a good question. That's almost an HR question. I'll let Sandra, if you have any input on that one.
I think it depends on what we're meaning by my own time. You know, are you saying that the research, the interview data that you're collecting has nothing to do with the reason why you're at the institution that you're at? It's a totally different area. It's not, you know, connected to the research and the work that you're doing at the institution that you're at. If that is the case, you can make an argument, I suppose, for it not being related to your position. But, you know, be aware that the university could also make the argument that even if you're collecting on your own time, you might be using university resources to conduct that, using databases that are provided by the libraries, using resources and research materials that may be provided by the institution, and they may feel differently about whether or not, even if it's not related to your particular area, whether or not it's not something that they can claim rights in. So I think it's a good question. But I think that there could still be an argument for the university that they may have rights in it.
I will mention, so my previous career was as an agricultural researcher, and we worked a lot with chemicals and things that could be commercially marketable. And it was very clear as a researcher in that field that even if I went to industry to work, any of the knowledge that I had gained from where I worked that would give me an edge, say, in developing something, even if I did it at home in my garage on my own time, would actually give my primary institution, my primary job, a claim on that invention. So intellectual property law seems to largely fall out in favor of the corporation. So again, you kind of go back to that ability to patent and get royalties off of it.
Okay, thanks. Could the university, like at OSU where you are, who owns the copyright on data, could it actually give rights to someone other than the PI for using that data? Okay.
Yes, absolutely. That is the reason why they own it, and when you talk with the Technology Transfer Office, they're the ones who quite frequently help you pair up with industry and help that data migrate into a commercially viable partnership. Now, the PI should always be involved, simply because they're the expert. They're going to know the nuances and the impact of that data. But the university is the one who arbitrates that, not the researcher.
I just wanted to add that the university, most universities are interested in things that are patentable. They see that as more opportunity to make money. Most institutions are, you know, if they find you bring them something that they believe can be patentable, they'll be looking for opportunities to license the invention to someone, as Amanda was saying, who's in industry who can be able to bring it to market. That isn't the person who created it or uncovered it or has done the innovation will likely still be greatly involved and will be, you know, the recipient of royalties, usually from a lot of those arrangements. But because the university is the one that has the rights in it, and again, not copyright necessarily in data, but patent rights, trade secret, that sort of thing, because the university may have the rights in that material, they are the ones who are really going to drive a lot of the processes with bringing some invention or some kind of creative, some sort of work that a faculty member may create to market. They're going to be very instrumental and very involved in that process.
Okay, thanks. We have time for a few more questions, so if you have questions, please type them into the question box. That Oxford group who was trying to require co-authorship for using their data that you said was unusual,
right?
Can that legally be, could that legally be enforced, that they require that?
Actually, if it's written in a data use agreement, it could. Now, I will say Oxford, of course, in the UK, we don't necessarily have the same laws there that we do here. So I don't know if that could be enforced internationally. But if it's part of the agreement, I would say yes. What would you say, Sandra?
Yeah, I would say yes as well. I mean, I think if you are, as a part of using some material, there's a part of the agreement that says you have to do X, Y, and Z. In order to make the use of the material, then you need to do X, Y, and Z. As Amanda said, I don't know how that would translate internationally for someone who is wanting to use a material who is in the United States or in China, and they are based at Oxford. I'm not sure how that would work, but I mean, typically contract law is contract law, and if there's an agreement and you're saying, I want to use this data, I'm going to use this data, you are saying that you're going to adhere to whatever they put out in the contract. I think it's interesting that they did, once there was a lot of pressure, you did see that they backtracked on that and I think moved away from that. Is that right, Amanda?
Yes, absolutely. If you follow that citation, the researchers really do come out and say we've absolutely never done that and we're not even sure why that's in there, kind of thing. I really chalk it up to being new to this arena of data sharing and reuse and how we kind of fit these new activities into our current workflows.
Okay, thank you. That looks like that's all our questions. So thank you, Sandra and Amanda, for your engaging presentation on data ownership and copyright. Thank you to all our attendees. We hope you found today's session useful. You will soon receive a short online evaluation form. Please take a few minutes to respond to the questions and return the form to us. Your comments are very valuable and help the ALCTS committee plan new continuing education offerings. Information about all ALCTS webinars can be found on the ALCTS homepage. 2 more webinars are on the calendar for this year, and we have many more webinars planned for 2015. Please check out our web courses, and you can sign up for our monthly e-forums. Suggestions for webinars and other continuing educational opportunities are welcome at any time. Please contact any member of the ALCTS committee or submit a proposal for a webinar using the online form on the ALCTS webpage under Online Learning. I would like to thank Joseph Nicholson for providing technical support for today's webinar. The support he and his colleagues on the Technical Support Subcommittee provide make it possible for us to present these webinars smoothly. Thank you for joining us this afternoon, and we hope you will participate in other ALCTS for Continuing Education offerings again in the future.